and this is equal protection. So this runs from page number 12 all the way over in the outline to page number 25. So it's a big area for testing. And I assume all of you have to know equal protection. Is that correct? So let's get this down and get it wired. Let's do an overview before we get into the law. So here's the bottom line. If you're going to write on equal protection on a Common Law 2 exam, we have to have discrimination. You agree? No discrimination, don't write equal protection. Now there's two, again, we keep on going back. You have to have a government regulation, okay? So it's going to be the 14th Amendment. It's going to be a state law that discriminates. For your own knowledge, if it's a federal law, it's the 5th. And the reason for that is technically there is no equal protection clause in the federal government. They use the 5th Amendment due process clause. So you don't want to say a 5th Amendment federal equal protection violation. It's due process when you're doing the 5th federal, states, 14th Amendment. That's probably what you're going to get on the examination. Now, in order to write on equal protection, you've got to find discrimination. So what we're going to make you do right off the bat is look for an arbitrary classification. What does that mean? That means treating men different than women. That means treating people of national origin different from U.S. citizens. It means treating African Americans different from Caucasians. It means illegitimates different from legitimate. It means you're drawing a line. There's actually some type of line drawing. I'm going to call this up here the classification. There's lines being drawn by the government. Then you know it is now at issue. Now what you have to do when you recognize that on your examination is it's imperative that you have an attack plan on how to do this. So the first thing we have in the outline, at the very top of the outline is a little blurb. It says on page 12, caveat, highlighted, individuals similarly situated must be treated the same. Individuals similarly situated must be treated the same. What does that mean? That means a government regulation cannot discriminate. Top of page 12, look for an arbitrary classification. You have to find a classification or you're writing on the wrong topic. Now, once you're able to see that there's a classification involving the 14th Amendment state law or 5th Amendment federal law due process, then the first thing I want you to do is I want you to head note at the top of your paper equal protection. So when I say IRAC equal protection, I want a head note that says equal protection. And then what I want you to do in your actual rule, which is in the outline, I want you to find a government regulation which draws an arbitrary classification treating individuals similarly situated differently. A government regulation which draws an arbitrary classification treating individuals similarly situated differently. That is your rule statement that you want to use on your examination. It's in the outline, the next page, so stay with me. If you find a government regulation which draws an arbitrary classification treating individuals similarly situated differently, then the next thing you want to do is find state action. You want to find state action. You want to find governmental action involved here, because if it's purely private conduct, it may not violate the Equal Protection Clause. So we need state action. We'll go through that in a few minutes. Public function test, significant state participation test. Sometimes professors want you to discuss de jure versus de facto. Have you heard those terms in class, by the way? De jure means what? On its face, by its terms, where de facto means what? Means basically only neutral unless it's some type of what? Some type of motive, etc. We'll discuss that as well. And then you get into classifying the discrimination. Now there are 3 tiers, okay, of levels, I guess is the appropriate term, 3 levels that we have to go through. The first level is called non-suspect, non-fundamental. And look at this over here. This is analogous to this. It's analogous to the first prong of substance due process, economic social regulation. What test did we use over here if it was non-fundamental? Rational basis. Lo and behold, what test do we use over here? Rational what? Rational basis. Same test. There's no difference. So if it's a non-suspect, non-fundamental right, who's going to win 9 times out of 10? The government's going to win. They can always prove what? Rational basis. Minus 2 cases. I'll go over in a minute, Romer and City of Claiborne. The second tier is called quasi-suspect. Sometimes we refer to this as intermediate what? Scrutiny. And we'll go through that in a minute. The test is different. It's substantial relationship to important governmental objective, the Craig versus Boren case, the alcohol case. And the third tier or third level is called suspect fundamental right, and it's strict scrutiny, compelling state interest, alternative mean. Now let's say that again. Suspect fundamental right, strict scrutiny, compelling state interest, alternative mean. Well, that's identical to this. That's the same thing I have over here. But what's the difference? Fundamental right, compelling state interest, strict scrutiny, alternative means, exactly the same test over here. You agree? But what's the difference in the fact pattern? The difference in the fact pattern is here it applies to who? Everybody. Here there's a what? A classification.